Some of the news that came within the last 24 hours are that the state is not going to be reimbursing for abortions for several months. So you're not going to see money going out for abortions. We still had contended that we needed injunctive relief because the staff is going to be processing reimbursements at the state. Now today, the judge granted the motion to dismiss of the defendants, the Attorney General's office, dismissing the case on the merits. We asked for a ruling as well, though, on our temporary restraining order request. What that does is triggers an expedited appeal process under the Illinois rules, such that we're going to need to file an appellate brief by the 2nd of January. And so we will be proceeding immediately to the appellate court here in Springfield, the 4th District, in order to undertake an appeal and try to stop the effectiveness of House Bill 40.
You mean in order, by filing TRO here, that kicks that appellate,
Right.
It gives you the chance to get an appellate TRO?
There is an expedited process provided under the Illinois rules. We're also going to seek to expedite all of the briefing. And in part, there have been a lot of pages of writing on these topics, and they're relatively simple topics. Did the bill pass on May 10th or did it pass on September 25th? And then also, is there a revenue estimate? We would say no, and that should have been fatal to the appropriation. So we will take that up on appeal. Again, we are disappointed with the circuit judge's opinion today, but we're going to take it on appeal, and we're very familiar with having to take negative rulings in the trial court up on appeal to get it reversed.
We've all been around and seen this kind of action in the court. What the judge said, it's typical of what a judge would say. This is a political decision, and we don't want to get involved in what the legislature does.
Well, and I'm disappointed both with the Attorney General's office and with the defendants for trying to say that the balanced budget requirement of the Illinois Constitution is not effective in some way. On the one hand, the Attorney General's office said and conceded that there's a duty to adopt a revenue estimate and to appropriate within that revenue estimate. On the other hand, knowing full well that the General Assembly didn't adopt a revenue estimate, they're willing to say, sorry, there's no way to actually hold the General Assembly to account. I think most people who have observed the General Assembly, certainly in recent years, would say somebody needs to rein these guys in.
The scale is shocking, surprising, and not so much. Where does today fall?
Disappointing. Today was disappointing. I had hoped that, I'm sure the Attorney General got the same response when the Attorney General's office got the same response when circulating her briefs as we did amongst our lawyers. Our lawyers thought we had the better of the argument. Most regular folks I talk to think we've got the better of the argument. I hope that the appellate court will agree.
With due respect, I don't think you answered the question. Shocking, surprising. That's not the same as disappointing. It's stipulated disappointing.
Right. No, I would say you never predict what a trial court is going to do, and so it's always you're never quite sure what's going to come out, and so predictions are tough.
Without the revenue estimate, should all the appropriations be thrown out?
Well, and this is. Our point is, we don't need to get there. This House Bill 40 was thrown on after all of the appropriations debate and dispute. And so we don't need to go into the other broader issue. I think you're going to see a lot of legislators, hopefully, pay attention to this revenue estimate issue, because you should know how much money you've got before you start doing the spending, if possible. And again, I think certainly there's no estimate showing revenues available to pay for House Bill 40, particularly when we see these statistics now that we're $1.7 billion in the hole in actual revenues.
Representative, you mentioned a bit about the initial passage of this back in May and how you guys were contemplating a lawsuit then, but then they delayed it, and it was kind of public that the governor could possibly veto it. So talk a bit about the delay in actually getting it sent to the governor and how that impacted your guys' litigation.
Well, and this was one of the arguments here today. To somehow say that a bill is passed when it's subject to a motion to reconsider, everyone knows the bill's not passed. It's not done. You can't send it to the governor. So somehow to pretend that it's passed is a fiction. And here, in this particular case, the governor had made a public, well-publicized veto threat that was credible. And so no one thought this bill was going to go into effect. It popped up late in September folks had gotten some slight notice, and then the governor all of a sudden signs it. So certainly the bill was not in the legislature's mind when the appropriation was enacted in July. And so really the situation of this bill shows the harm of saying, hey, you can hold a bill on a motion to reconsider, kick it out whenever you feel like it, and we're going to let it be effective on a short date instead of punishing you as the people and prior General Assemblies had put into the Constitution that, hey, if you get your work done by May 31st. The Constitution says get your work done by May 31st, or else your bills don't have short effective dates.
I think that's an
Why isn't
interesting point that you
HFS
made in court. How much of this is about, the governor's all in for abortion rights and the governor's not an honest broker? How much of this is on him?
And we've really shifted to the issue and to the issue of the taxpayer funding from now. I know there are a lot of folks taking whacks at the governor, and that there are plenty of other folks, and there's an active political campaign going on. So I'm going to leave it to them to really take the good hard whacks.
Why isn't HFS reimbursing reimbursing abortion?
Well, so current state law prohibits it,
Right.
and has prohibited it for
I'm
decades.
sorry. You're saying until January 1st.
Until
there's no-
January
all right.
1st. And so that's the issue. So you've got you'll have a change in law. HFS will start to receive reimbursement requests. Again, their pleadings had shown that they will. It takes them about a month to turn those around. It will then take the comptroller a couple months to actually issue checks. So you're looking at April before money flows for abortions. But you're going to have abortion procedures starting January 1st, where folks are going to be expected to get state reimbursement, and they may not be actually getting state reimbursement.
And I just wanted to be clear about that, because at the beginning, what you were saying, there's no sort of truce. You had called for the state or the administration to kind of hold off on this while this court case proceeds. That's not what's happening. You're just saying that you have a few days to file your appeal, and then
We have 2 days under the Illinois rules to file an appeal of a temporary restraining order. So it's a very short time. That's lightning speed in legal time.
But the state's not backing off their position.
The administration, the executive branch, and the Attorney General's office have not backed off an inch. In fact,
Well,
they're pushing ahead.
as a practical matter, one day, correct, one business day before January 1st.
Right. So we will file on, at least I believe we are due to file on January 2nd, which would be the first day government reopens after the new year. And so you'll have us on file right away. Under the Illinois rules, as I understand, then the Attorney General's office will have 2 days to respond. The appellate court will take the matter under, I would imagine, they would issue a decision pretty quickly.
And if you're successful, then an existing state law would be suspended,
That would be the hope.
injuncted.
Yes, that is what we are attempting to do, is to push off the effectiveness. Again, we're heartened by the fact you're not going to see any money flowing out for abortions until April, but you are going to have state dollars used to administer the program, and you're going to have abortions performed starting January 1st, where folks are expecting a state reimbursement. And so actually, if anything, that uncertainty is not necessarily good for the process either.
Medicaid dollars cover abortions for certain cases.
Very rare. You've
This
got a
will-
handful.
This will be full state dollars, no federal
Right.
dollars involved.
It's full state dollars. There is no federal reimbursement for elective abortion coverage, which we've identified. It's everything but the rape, incest, life of the mother abortions. So everything besides that gets covered. So
Yes.
any abortion, anytime, any reason.
So Illinois is a traditional Hyde Amendment currently.
Absolutely,
Rape-
we've been for
Rape,
decades.
incest,
Right,
endangerment,
right.
and money.
Yeah, and we were the first state to ever provide funding for Medicaid funding for abortions through the legislative process. Every other state, the other 15 states that had provided it, 11, their courts had imposed it on the people. The other 4 had legalized abortion pre-Roe v. Wade. And of course, in Illinois, we, like most states, had not legalized abortion.
Now, based on what happened here today, is there anything that could be changing when you're filing to appeal based on?
No, after today's argument, I'm more confident than ever in the truth and the correctness of our position. I heard nothing today from the Attorney General's office that caused me to think that somehow the General Assembly has done its job any more than it had a few days ago. I'm confident in the correctness of our legal argument, and I'm very hopeful that we're going to be able to get this decision reversed on appeal. Again, we have a lot of experience at the Thomas More Society in taking punches at the trial court and then getting them reversed over on appeal. So yeah, this is not new for us at the Thomas More Society.
great.
If this judge thinks that she's overstepping by making a ruling on this case, what makes you think an appellate court will rule any differently?
Right, well, and that's the point of a court of appeals. And one of the, there's a reason you have 3 judges. They have a different viewpoint. And I'm very much hopeful that we will get some relief from the appellate court. And if we don't get relief from the appellate court, then we'll go to the Supreme Court.
Now, I know this is a delay. Is there any long-term goal to somehow repeal this decision?
Well, and as a broader part of the picture, those folks who had passed House Bill 40 thought they were taking abortion off the table. The problem is they're now injecting it into every single year's appropriation process. Because now, every single time we do an appropriations bill at the General Assembly, there's going to be the question, are we going to be funding elective abortions? 20 to 30,000 of them, every single year. And we've heard the evidence shows we're $1.7 billion in the hole already for this fiscal year. Next fiscal year, my view of the estimates is that we're $3 billion in the hole before we even start the budget process. So putting aside millions of dollars for elective abortions is going to raise some issues and some questions amongst the members of the General Assembly, and it should.
What
So
kind
are you
of
hoping-
legislative action are you looking at after this? Are you
Well,
looking to repeal it through
Sure,
legislation?
and we've got the No Taxpayer Funding for Abortion Act has been filed. That's something that I think is going to be refiled every year until House Bill 40 is repealed. But again, the annual appropriations process every year is going to now involve a discussion about whether we fund elective abortions. And in fact, the Hyde Amendment in Washington, D.C. is the same way. They re-adopt the Hyde Amendment every year. It's been re-adopted every year since 1976, but it is re-adopted every year. So in Illinois, we can take that tack, especially in view of our dire financial straits.
I just want to be clear, one point that the Attorney General's office made about this idea that because there's no revenue estimate, why isn't the entire state budget negated?
Well, and I will tell you that question is one that we don't have to get into. And so that's something that, if you ask any member of the General
But
Assembly.
you got into it.
Well, I
right?
got into
You
a little
raised
bit.
the argument,
I
so
did raise the argument.
Why is...
Here's the issue. So House Bill 40 is a little bit different in that it was not part of the principal appropriations process. And so, you can ask the question, hey, I think most members of the General Assembly would tell you that, yes, we should adopt a revenue estimate. The law actually requires us to do so by March. That did not happen this year. It should happen every year. For whatever reason, and I'm on the House side, on the legislative side, no revenue estimates saw the floor in the House. I know multiple revenue estimates were filed, and that's disappointing as a legislator that we wouldn't even take the time or take the care to determine how much money is coming in. I mean, those are your tax dollars, and we're just spending them without an idea of how much is available.
So you're just not going to address the slippery slope argument?
Well, the slippery slope. Here's the thing: slippery slope is not a valid argument. Here, particularly, we've got a late item. It's new spending that was not part of the primary appropriations package. Where's the money? And everyone knows there's no money. So that's the other thing. So it's both a legal argument. It's legally sound. The Constitution requires an estimate of revenues available. There are none, and it's factually correct. Everybody knows we don't have any money for it. But the administration wants to press on, the Attorney General's office wants to press on.
Thank you.
Okay.